Imagine for a second that you're a content creator, right? You're out in Nevada, the sun is beating down, and you decide to film what is, well, essentially a harmless street prank.
Right, just a classic viral setup.
Exactly. So you've got a tiny microphone hidden under your shirt, and a buddy is filming you from across the street with a telephoto lens. You walk up to a stranger, you capture this hilarious, completely spontaneous interaction, and you upload it.
And it just explodes.
It goes totally viral.
Yeah.
We're talking millions of views, trending on every single platform. It's, the absolute dream scenario for anyone trying to make a living on the internet today.
It's a golden ticket, really.
But then, imagine you get into your car, you drive 3 hours west, you cross the border into California, and you decide to replicate that exact same magic.
Oh, boy.
You do the exact same prank with the exact same hidden microphone setup in the exact same way. And instantly, the very second you capture that audio, you have committed a crime.
Yep. It's an instant felony in some cases.
Just by crossing an invisible line on the highway, your viral comedy format basically becomes a criminal wiretapping offense.
It really highlights a terrifying reality for anyone holding a smartphone right now. I mean, you cross a geographical line, and the entire legal reality of what you're doing just inverts itself.
It's crazy.
We don't often think about laws changing at the border when we're just, recording video, but they do, and the consequences are massive.
Welcome to this deep dive. Today we are looking into the invisible legal tripwires hiding behind every single viral street video, every prank, and every public interview you see on your feed. And let me tell you, there are a lot of them.
There are so many.
We're exploring the hidden risks of filming strangers for internet content. Our mission today is to really map out these stark and honestly pretty terrifying boundaries that divide the free speech first approach of the United States and the privacy-first approach of the European Union.
And this matters profoundly to you, the listener, whether you're the creator holding the smartphone trying to build a channel, or if you're just a regular person trying to walk down the street to get a coffee.
Right, because we're all in public.
Exactly. There are massive unseen forces dictating exactly what can and cannot be done with your image, your voice, your identity. I mean, we constantly consume this content. We scroll through TikTok or Instagram and watch these street interactions without a single second thought about the legal machinery grinding away in the background.
You open up any app, and it's just an endless stream of street interviews, gotcha moments, people thrusting microphones into the faces of unsuspecting pedestrians.
Constantly.
We watch it, we laugh, we share it, and we operate under this massive assumption. We assume that because the camera is out in the open, because the environment is a public sidewalk or a park, everything is just fair game. It's what's often referred to in the sources as the public space illusion.
The public space illusion is exactly what we have to dismantle first. It's basically the tale of two entirely different legal philosophies colliding with the exact same consumer technology.
Right.
To really grasp the stakes here, we have to look at that foundational assumption. We have to examine this deeply held belief that if you step onto a city sidewalk, you just automatically surrender your expectation of privacy.
Well, in the United States, that baseline assumption actually holds up almost perfectly, doesn't it? I mean, if you're standing in public, you're pretty much fair game.
It does, yeah. The legal framework in the U.S. is anchored completely by the First Amendment. It operates on this foundational principle that the public square has to remain an open forum.
So cameras are just part of that open forum.
Exactly. Any restriction on recording in a public space is generally viewed by the courts as a direct threat to a free press or to citizen journalism. The courts have historically been, terrified of giving the government the power to say, you can't film here.
Because historically, that power gets used to hide things, right? Like police misconduct or political protests.
Precisely. If the government can shut off the cameras, they can hide what they're doing.
So the philosophy is basically that if an event is happening out in the open, if the general public can see it with their own eyes, the simple act of capturing it with a lens is a protected form of expression. It's just information gathering.
That's the core of it. The First Amendment provides incredibly broad protections for that specific act. Think about standing in Times Square.
Okay, tons of people.
Thousands of people, hundreds of cameras, tourists, professionals, bloggers. A creator doesn't need to walk around with a clipboard and secure a release form to capture your face in the background of their shot.
That would be a logistical nightmare.
The sheer logistics of that would make public photography literally impossible.
But it goes even further than the background, though, because you could be the main subject they're zooming in on, and they still don't need your permission in the U.S.
Right. They really don't.
Your presence in that shared public space is treated as something that anyone else present can observe, and by extension, they can record it and publish it to the entire world. I was trying to wrap my head around this earlier, and a specific analogy came to mind based on the sources.
Sure.
In the U.S., the law essentially treats a camera in a public space like a mechanical extension of a pair of human eyes.
Oh, I like that.
Yeah, so whatever your eyes have the legal right to observe on a city sidewalk, whether it's a street performer, a person eating a hot dog, or just someone tripping over a curb, your camera has the exact same right to capture and share.
That analogy actually maps perfectly onto how the U.S. framework operates. The camera is just a technological surrogate for human observation.
So if you don't want to be seen, what do you do?
Well, the burden is entirely on you to stay inside your private home, pull the blinds down, and lock the door. The moment you step outside your door, you enter the domain of public observation.
You're out in the wild.
Exactly. The courts basically say you chose to enter the public square, so you accept the risks of the public square.
Okay, but what happens when you take that exact same camera, that exact same vlogger, and that exact same sidewalk scenario, and you drop them into Berlin, or Paris, or Rome?
Everything changes.
Because according to our deep dive, that simple location change completely shatters the entire framework we just talked about.
It inverts it completely. The European Union operates on a fundamentally different frequency here, and it is all because of the General Data Protection Regulation, or GDPR.
Right, GDPR. I think most people know GDPR is that incredibly annoying pop-up that makes you click accept all cookies on every single website you visit.
It is definitely that.
It feels like a purely digital, behind-the-scenes internet annoyance. I don't really think of it when I'm holding a physical camera in my hand.
And that right there is the trap. People think it only applies to digital tracking or web browsers and email lists, but GDPR has a massive physical, real-world application. Under EU law, your physical face, the actual arrangement of your eyes, nose, and mouth as you sit on a bench in a public park, is legally classified as biometric data.
Wait, I really need to stop and dwell on that for a second. My physical face is biometric data?
Yes.
Just by existing outdoors.
Just by existing. It's a unique identifier of a living human being. I mean, in the digital age, a photograph isn't just ink on paper anymore, right?
Yeah, it's digital.
It's a data matrix. It can be fed into facial recognition software, cross-referenced with social media profiles, and used to track your location. Because of that, under EU law, your face is subject to the same strict protections as your medical records.
Or like the password to your bank account.
Exactly the same level of protection.
Okay, I'm struggling to bridge this gap a bit. In the US, my camera is basically my eyeball. Over there, you're saying my camera is a data harvesting machine.
That's exactly how they view it.
If my face is just taking up physical space outside, how is it data? It sounds like instead of a pair of eyes, the EU treats a camera like a literal data vacuum. How did we end up with two totally different definitions of what a camera even is?
To really understand the mechanism, you have to look at the history of the region. European laws are deeply rooted in post-war trauma.
Okay, like World War II.
Yes, and the Cold War. The continent has a very dark, very recent history with the systemic cataloging, tracking, and surveillance of citizens. Think about the Gestapo or the Stasi in East Germany.
Where neighbors kept files on neighbors.
Exactly, and any photograph could be used to disappear someone in the middle of the night. Because of that severe historical trauma, their legal systems prioritize human dignity and individual privacy above almost all else.
That makes total sense. They've seen what happens when that goes wrong.
Right. There's a deep-seated institutional caution regarding mass surveillance or the non-consensual cataloging of citizens. So the mechanism of GDPR isn't just about punishing big tech companies.
It's about protecting the person.
It's about protecting the individual's absolute right to control their own identity.
So EU citizens essentially walk around with this invisible shield of privacy rights, even when they're completely outdoors. The right to control how your image is used doesn't just vanish because there's no roof over your head.
Exactly. The individual's right to their own dignity completely trumps your right to press record. Now, to be clear, the physical act of simply hitting the record button might not instantly trigger a massive lawsuit or a police raid in Europe.
Right, they aren't tackling tourists.
No. If a creator is just capturing, say, a wide architectural shot of a gorgeous cathedral in Rome, and there happen to be faces in the crowd that are totally incidental to the shot.
Just blurry figures walking by.
Right. That is generally understood to be okay. The legal mechanism doesn't really care if you're just capturing the vibe of a city.
You aren't trying to harvest the crowd's data. You're filming a building. The people are just set dressing.
Precisely. The real legal tripwire, the moment the trap actually snaps shut, is the point of publication.
Uploading it to the internet.
Yes. Taking that footage, especially if it focuses on specific individuals, zooming in on their reactions and uploading it to a global platform without explicit consent.
That's where you get in trouble.
That's where the devastating legal risks lie in Europe. It's the broadcast of the biometric data that violates the dignity of the subject. You've taken their private existence and turned it into public content without asking.
Okay, so sweeping architectural shots of cathedrals are mostly fine. But let's be honest, that's not what's going viral on TikTok or YouTube.
No, definitely not.
Nobody's building a massive, highly profitable channel just showing wide shots of buildings. Most of the content on our feeds is definitely not passive observation. Creators are actively seeking engagement. They want reactions.
Which totally shifts the conversation from passive observation to active provocation. A huge portion of the creator economy is built on what's categorized as gotcha content.
Oh, we all know exactly what this is. It's the creator walking up to a total stranger, thrusting a microphone into their face, and asking them deeply provocative questions.
Right out of nowhere.
They ask about controversial politics or how much money is in their bank account or what their most toxic relationship trait is. They're basically mining for shock value.
And in the EU, when a creator crosses that line into provocation, the core legal issue shifts. It goes from simple data protection to the explicit protection of human dignity and reputation.
Which is a huge deal there.
A massive deal. If a creator engineers an interaction specifically to mock someone, to confuse them, or to extract some kind of controversial, embarrassing statement, and then they publish that content, the legal consequences in Europe are incredibly severe.
Because you're hurting them on purpose.
You're actively degrading their public standing for profit.
I hear that, but I have to admit, I'm trying to puzzle this out organically. Let's say I walk up to a guy in Paris. I put a microphone right in his face.
Okay.
He doesn't run away. He doesn't put his hand over the lens to block it. He voluntarily chooses to stand there, look directly into my camera, and argue with me about politics for 10 whole minutes.
He's engaging with you.
Right. He made that choice. He didn't have to answer me. So how on earth can he later claim that I violated his privacy when he actively, knowingly participated in the game? Hasn't he implicitly agreed to the whole thing at that point?
That is the exact logical dilemma that traps so many American creators when they travel abroad. We assume that participation equals distribution.
It seems like common sense.
It does, but under GDPR and EU privacy frameworks, agreeing to speak to someone on the street is a completely separate legal act from consenting to the global publication of that conversation.
Wait, they're two completely different things.
They're completely separate. Think about the reality of the situation on the street. A person might answer a question just because they're caught off guard.
Or they're just being nice.
Right. They might answer just to be polite to a stranger who's standing in their way. They might think they're participating in a small, harmless local student film project or just a street poll for a tiny local blog.
So their physical participation in the moment is not a blank check for global distribution.
Exactly. They haven't consented to their potentially embarrassing, off-the-cuff response being broadcast to 10 million people on a TikTok feed in perpetuity.
Wow.
Doing so without their explicit, informed consent violates their human dignity. The consent for publication has to be unambiguous. You cannot just infer global broadcast rights simply because the subject decided not to sprint away from your camera.
That makes a lot of sense when you put it like that.
The burden is entirely on the creator to prove they explained exactly where this video was going and that the subject explicitly said yes.
That completely changes how you view every single street interview filmed in Europe. You look at those videos and wonder, did they actually get a signed release after that, or are they just hoping the guy never sees it?
Usually they're just hoping.
Okay, so flying back across the Atlantic to the United States, we've established that the First Amendment gives American creators significantly more freedom to push these boundaries.
Very much so.
We see confrontational street debates and prank videos dominating American platforms. But the U.S. isn't just some lawless free-for-all either. There are boundaries.
Right. There are absolutely boundaries. The U.S. isn't the Wild West, but the limits are defined by entirely different legal mechanisms.
So not broad privacy rights.
Right. Instead of broad, overarching privacy rights like the EU, the US relies on specific torts, which are basically civil wrongs that you can sue someone over. The main ones to worry about are defamation, intentional infliction of emotional distress, and something called false light.
Let's break those down. Defamation is fairly well known. That's when you publish false statements, present them as absolute fact, and it damages someone's reputation.
Right.
Like if I make a video claiming a specific local bakery uses rat meat, and I have zero proof, they're going to sue me into oblivion.
Correct. You presented a harmful lie as a fact. And then there's intentional infliction of emotional distress, or IIE. That requires conduct that is so outrageous, so extreme that it causes severe emotional trauma to the victim.
That's hard to prove, right?
Extremely hard. It's a very high bar to clear in an American court. The courts really don't want people suing just because they were mildly annoyed or embarrassed by a prank.
So what's the real danger then?
The most insidious risk for modern internet creators, the one that actually ruins careers, is false light.
This one is fascinating because it essentially turns the video editing room into a massive liability zone.
It absolutely does.
It involves deceptive edits that fundamentally misrepresent who a person is or what they believe. Let's bring this to life. Imagine a creator is out on the street and they walk up to a complete stranger.
Okay, setting the scene.
The creator asks a totally innocent question, like, hey, are you having a great day today? And the stranger smiles, gives a huge thumbs up, and nods enthusiastically.
A perfectly harmless interaction.
Right. But then the creator goes back to their studio.
Okay.
And in the editing room, they delete the audio themselves asking about having a great day.
I see where this is going.
Yeah, they record a new voiceover asking, do you support kicking puppies? And then they lay that new audio over the original visual footage of the stranger smiling and nodding enthusiastically.
And that right there is the textbook definition of false light.
The terrifying part is that the visual footage hasn't been altered at all. It's completely truthful visual data. They really did smile and they really did nod. It's not a deepfake.
But the context is completely fabricated. You're using truthful visual footage, but you're constructing a fundamentally deceptive narrative. You're presenting a lie using the truth.
And the First Amendment doesn't protect that.
No. Even under the incredibly robust protections of the First Amendment, you cannot use misleading edits to alter the truth of a person's actions to their detriment.
That makes total sense.
False light protects the individual from being presented to the world in a fundamentally deceptive and harmful context. It's highly actionable, and juries absolutely despise creators who do it.
So you can survive the visual edit if you just don't lie. But the irony here is the visual part isn't even the most dangerous component of the camera.
Not even close.
Up until now, we've focused almost purely on the camera lens. We've talked about visual data, capturing faces, and visual editing. But the moment you attach a tiny microphone to the top of that camera, the entire legal framework shatters all over again.
This is the audio trap, and it's where things get incredibly complicated.
And ironically, this is where the supposedly free speech first United States actually becomes vastly stricter and way more confusing than Europe.
It really does. Secret audio recording laws are drastically different from video recording laws. To understand this, let's look at how the EU handles it first, just to establish a baseline of sanity before we get to the American system.
Okay, what does the EU do with hidden microphones?
In the EU, the approach to secret audio remains completely consistent with their broader GDPR and privacy framework. Secretly capturing a person's voice without very strong, exceptional justification is strictly prohibited.
Because it's biometric data again.
Exactly. Because secretly capturing a person's voice is capturing biometric data without their knowledge. It's a clear violation of human dignity. The logic is just a straight line.
The EU draws a hard, consistent boundary. Video is strict, audio is strict. It's very easy to understand. But I am trying to figure out why the US is so messy here.
It's a historical mess.
Why is intercepting someone's speech viewed by American law as inherently more invasive than capturing their physical face on video? You'd think the First Amendment would cover both equally.
It's all about historical context. American audio recording laws don't stem from modern internet culture or smartphones or vloggers. They stem from mid-20th century wiretapping statutes.
Wiretapping, like old school spies, private investigators, and landline phones.
Exactly. Go back to the 1960s. You had a massive societal pushback against private investigators, corporate espionage, and covert surveillance.
Oh, right. Nixon, Watergate era stuff.
Exactly that era. There was immense paranoia about bugs in offices and taps on phone lines. The legislative intent back then was to prioritize the absolute sanctity of private conversations.
So talking was viewed differently than walking around.
Yes. Society decided that what you whisper to someone in a diner booth should be protected from interception, even if your face is completely visible to the rest of the diner. The law bifurcated. What you show the world is public, but what you say to a specific person is private.
Wow. Because of laws written for rotary phones before the internet was even conceived, modern creators are stepping into a literal jurisdictional slot machine.
A slot machine is the perfect way to look at it. In the US, these wiretapping laws are not federal. They are entirely dependent on state lines. And this creates a geographical nightmare for anyone holding a microphone.
So it changes state by state.
Drastically. The U.S. is divided broadly into two camps, one-party consent states and all-party consent states.
Let's explore this slot machine. Explain a one-party consent state. Let's use Nevada or New York as an example.
In a one-party consent state, the law dictates that only one person involved in a conversation needs to be aware that the recording is taking place for the recording to be legal.
Only one person.
Yeah.
So if I'm a creator and I have a hidden microphone taped to my chest and I walk up to a stranger on the Vegas Strip and start talking to them, I'm a party to the conversation.
You are actively participating. And because you know about your own hidden microphone, you count as the one party who is consenting.
That is just wild. The creator holding the hidden mic acts as their own legal permission slip, making the secret recording of the stranger completely 100% legal without them ever knowing.
It feels like a loophole, but it's the law. In New York or Nevada, you can secretly record the audio of a stranger on the street, provoke them, get them to say crazy things, and publish it without ever disclosing the microphone. You're legally in the clear.
But then you encounter the other side of the coin.
Right. States like California, Massachusetts, or Florida, these operate under all-party consent laws.
And based on the name, that means every single person involved in the conversation must know about the microphone and consent to being recorded.
Every single person. If there are 5 people in the conversation, all 5 must know and agree. If you secretly record someone in California, you are committing a crime, regardless of whether you're participating in the conversation or not.
Because you didn't get their consent.
Right. You're effectively wiretapping them.
Which brings us right back to the opening hook of this deep dive. The geographical trap.
Yeah.
This is exactly why a creator can drive from a one-party state like Nevada into an all-party state like California, perform the exact same hidden mic prank, and accidentally become a criminal wiretapper.
Yep.
They're holding the exact same phone, doing the exact same bit.
It highlights a profound friction in modern media. The internet is a completely borderless medium. You scroll through YouTube and you consume formats from all over the world simultaneously.
And you just assume it's legal everywhere.
Exactly. A kid in California sees a creator successfully executing hilarious hidden microphone interviews in New York. They think, that's a great format, I'll do that at the Santa Monica Pier.
And they attempt to replicate that exact format, completely oblivious to the fact that they're violating strict state wiretapping laws. The rules literally spin like a slot machine, depending on where your physical feet are planted on the ground.
It's an incredible paradox. In California, you can film a person's face freely under the First Amendment, but if you capture their voice secretly with a lapel mic, you might be committing a felony depending on your GPS coordinates.
And people really go to jail for this.
The enforcement here isn't just a slap on the wrist. People face serious criminal charges for wiretapping.
Facing all of these massive, terrifying geographical contradictions, it's easy to feel like you just shouldn't ever film anything outside your own house.
It can feel very overwhelming.
You're constantly dodging GDPR, false light, state wiretapping laws. But there is a way to actually navigate this. There are what's known in our sources as the universal red lines.
Yes. The universal red lines are the actions that will get you sued, arrested, or demonetized no matter where you stand on the globe.
So things everyone agrees on.
Exactly. Despite the massive philosophical differences between the U.S. First Amendment and the EU GDPR, the legal systems actually agree on a few core boundaries.
Let's list these out. What are the shared illegal acts globally?
There are 4 primary universal red lines. The first is harassment.
This seems obvious, but clearly, people need reminding, especially with the rise of IRL streaming. In real-life streaming, where creators walk around for hours bothering people for donations.
It's become a huge issue.
Holding a camera does not grant you some magical immunity from basic harassment laws.
Yeah.
You can't use the guise of content creation to stalk, intimidate, or relentlessly bother someone who has clearly indicated they want to be left alone.
The camera isn't a shield against criminal harassment. If a reasonable person would feel threatened or endlessly harassed by your actions, you've crossed a line, regardless of your First Amendment rights.
What's the second red line?
The second universal red line is private spaces. We talked about the public square being open in the U.S., but the expectation of privacy holds firm globally when you cross certain physical or situational thresholds.
Even with the First Amendment backing you up, you can't put a telephoto lens on your camera and point it into someone's second-story bedroom window from the street.
Definitely not.
You can't film inside a public restroom. You can't film inside a medical facility or a triage tent. Anywhere that a reasonable person expects absolute privacy, the camera must power down.
The global legal consensus is that your right to record ends where another person's reasonable expectation of privacy begins. That boundary is universally respected.
Okay, that makes perfect sense.
The third universal red line is one we explored in depth earlier, which is false light and misleading edits.
Right, the puppy kicking example.
Intentionally manipulating footage to lie about a subject's actions and causing them harm as a result is universally illegal. Whether you're in Berlin or Boston, you cannot use deceptive editing to destroy someone's reputation. The courts everywhere despise malice.
Which brings us to the final red line. And I wanted to really expand on this because it seems to be the most rigorously enforced red line across the board.
It absolutely is.
The final red line is targeting children. The legal protections for minors are incredibly absolute.
The protection of minors is paramount globally. In Europe, under GDPR, parental consent is almost always a strict mandatory requirement. Children cannot legally consent to their biometric data being harvested and broadcast.
There's no playground videos.
You absolutely cannot casually film a child on a playground and upload it, regardless of your artistic intent or a lack of malice. It is forbidden.
And in the U.S., where we have the First Amendment protecting public filming, because I see family vloggers and pranksters featuring kids all the time.
Even in the U.S., where public space filming is broadly protected, targeting minors for gotcha content or anything that could be perceived as exploitative creates massive legal vulnerability.
Judges don't like it.
Juries and judges are incredibly sympathetic to minors. The culture is rapidly shifting against the exposure of children online without their consent, even by their own parents.
That's a huge shift.
Children are a universal legal risk. If they're the subject of your content and you don't have explicitly documented parental consent, you're operating in the danger zone. You might win the legal battle eventually, but the process will bankrupt you.
So knowing these rules, don't harass people, stay out of private spaces, don't lie in the edit, and leave kids alone knowing the actual statutes is one thing. But practically surviving in the modern creator economy requires more than just memorizing a legal textbook.
It really does. You need a survival guide. Based on all these sources, there are 3 foundational rules for anyone operating a camera in public, designed to keep them safe regardless of the jurisdiction they happen to be standing in.
Let's hear them. Rule number 1. It's the simplest, but probably the most ignored by creators chasing a viral moment. Always ask for consent.
It sounds so basic, but consent acts as a definitive, universal shield. Even if a creator is standing in a jurisdiction where the law technically allows them to film and publish without permission, like New York City securing consent just eliminates almost all inherent risks.
It just shuts it down.
It stops a lawsuit before it can even be drafted. If you have them on camera saying, yes, you can post this, you've neutered 99% of legal threats.
Rule number 2 is complete transparency about publication. This is a big one because the scale of the internet is hard for normal people to really comprehend.
Transparency is vital. If you walk up to someone and say, hey, I'm just filming a little personal vlog for my family, can I ask you a quick question? And they agree to talk to you based on that premise.
But in reality, you take that footage and upload it to a YouTube channel with 3 million subscribers, and it gets monetized and chopped up into hundreds of TikToks.
Exactly. That massive deception invalidates any consent they gave you. True consent must be informed. The subject has to understand the actual magnitude of the distribution. You have to say, this is going on a channel with millions of viewers. Are you okay with that?
And rule number 3 is basically an ethical mandate. Avoid content that inherently harms or misrepresents the subject.
Which functions as a critical legal buffer against defamation and false light claims. If you aren't trying to make people look foolish, evil, or incompetent, you drastically reduce your legal exposure. The courts punish malicious intent.
This brings me to the ultimate so what question of this entire deep dive. Looking at these three rules, asking consent, being transparent, not harming people, it sounds like simply meeting the legal minimum isn't actually enough to protect yourself anymore.
Not at all.
You could argue the nuances of First Amendment rights or one-party consent in a courtroom all day, but that doesn't actually save your career, does it?
The reality of the modern internet is that the court of public opinion moves vastly faster and is far more brutal than the legal system. A lawsuit takes years of discovery and depositions. A viral backlash takes hours.
Right. A creator's reputation is their primary currency.
Absolutely. If a creator builds a brand on exploiting jurisdictional loopholes, relying on cruel setups, or tricking people into embarrassing themselves, it inevitably leads to audience backlash.
They eventually get canceled.
And when the audience turns, the platforms demonetize the channel, the algorithm suppresses the content, and the sponsors immediately sever their ties. Surviving this ecosystem is not just about avoiding a courtroom, it's about maintaining fundamental trust with the public. If you lose that, you don't have a career, no matter what the First Amendment says.
Let's summarize the core philosophies we've uncovered today.
We've looked at two entirely distinct approaches to the exact same technology. The European Union operates on a privacy-first framework. They prioritize human dignity and the individual's absolute right to control their own biometric data over the desire to broadcast.
While the United States operates on a free speech-first framework, the necessity of an open public square and the freedom to publish what the human eye can see takes precedence over personal privacy in public. Same camera, same street, complete different legal outcomes.
And this leaves us with one final fascinating dilemma to mull over based on everything we've talked about, the intersection of these two worlds.
Okay, picture this. Imagine an American creator in New York City. They're standing on a public sidewalk in Times Square, fully protected by the U.S. First Amendment. They film a provocative, mildly embarrassing street interview. But the stranger they happen to stop and film is a European tourist visiting from Berlin.
The American creator legally uploads the video globally from their apartment in Brooklyn. The European tourist goes home to Berlin, opens their phone, sees the video, and feels that their GDPR rights, their human dignity, and biometric data were fundamentally violated by the global upload.
It's the ultimate jurisdictional nightmare. Does your digital sovereignty, your GDPR rights, follow your passport wherever you travel? Or does that invisible shield of privacy vanish the exact moment you step onto American soil? It's something to really chew on the next time you see a ring light pointing your way on the street.
The content on the Diary of a Lawyer is provided for general informational, educational, and entertainment purposes only. It does not constitute legal advice or establish a lawyer-client relationship. Any reliance on this content is at your own risk. It is not a substitute for professional advice, including legal, medical, or mental health guidance. Always seek the advice of a qualified professional regarding any specific concerns you may have.